you again for coming to our webinar, New Laws in 2025. And we are going to have a lot to talk about because this year, above all other years that I've been doing this, and that's been for the last 10 years, there have been the most laws that have been passed to be enacted this year in the state of California than ever before. It was a prolific year for new laws, and so there are literally hundreds of new laws in the state of California. And there's a couple of federal ones that we're going to touch on, but we're not going to go over all 100. So don't worry about it. I'm not going to be talking like the micro machine guy, talking really fast like an auctioneer. I've selected out the ones that are going to be the most applicable for you today in regards to estate planning, planning for aging, and then planning if you have children. So we've kind of pulled out, and of course I can't forget business owners because I am one. So those are the ones that we pulled out, ones that are going to be germane to planning. So trusts, wills, are there any law updates there? Taxation, updates in the law there. We're going to be talking about updates in the law for business owners. How can we protect our loved ones, whether they're our aging loved ones or are there little kiddo loved ones? Some of the laws are particular to that. So we have a lot of great things to share. Oh, I jumped ahead really fast there. And so we're also going to talk a little bit about looking ahead. So I'm going to fill your brains with knowledge about what changed for this year, what is in place now, and then we're going to have a short discussion, or I'm going to share with you some of my thoughts about what is ahead of us coming into 2026, because there's a lot of conversations that are being had about that at the legislative branches at the federal level. And you see some of that if you're reading the newspapers. There's some of that coming out. And so there's a lot of speculation, and I'm going to give you my 2 cents about that. So lot to cover today, so we're going to just jump right to it. Most of you that are coming in on this webinar know who I am and who we are. If you're new, then you got here because you know who we are. So we're an estate planning and elder law firm. We help people from across spectrums, whether you are a parent, a single person, business owner, professional, you have some tension points in your life. You're concerned about what happens if something bad happens to me and I'm incapacitated or I passed away. How does that affect me? How does it affect my family? How does it affect my business? How does it affect my aging parents? And what about my aging parents? How can I during life help them as they age and we encounter a lot of different challenges as we age? So that's what we're about, helping you during life to traverse these challenges and set you and your family up for success for the bumps in the road that are going to come in the future. Can't take the bumps away. I tell clients, can't keep them alive. I can't treat an illness. I can't prevent an unexpected event. But what we can do is help make that road and that path less bumpy than it would have been. And so that's what we aim to do today, is giving you all this good, important information about the changes in the law so that you can be ahead of the game. All right, so first things first, we always like to start with tax. Why? Because that's what people ask me about. So what is going on with the taxes, Kevin? And this is important stuff. So for the last couple of years, we've had a change in the law in regards to how much you can gift, meaning give somebody without getting taxed. Now remember, the way that we have the whole federal structure set up, and this is a federal law we're talking about, so it doesn't matter what state you're in. We are in California right now. We are licensed in California, so we're only going to be talking about laws generally today that affect Californians. Even if we're talking about federally, this presentation is geared to you, the Californian resident. So that's not geared towards you, the Nevada or Tennessee or Texas resident. Okay, so just that's my little disclaimer. But the focus, this is something that does affect everybody. So the IRS said this year we're going to change it. Because there's been a lot of inflation, we're going to up the gifting ability, which means you can give somebody up to $19,000 a year without incurring a tax. And remember that the structure is the giver, it gets taxed, not the recipient. All right, so that's just how it was set up. It's like we want to we want to tax the giver. So if you gave $20,000 to somebody, then the IRS can tax you for making a $1,000 gift over this threshold. So we're gonna not want to do that. So we're only going to give $19,000 to somebody. And guess what? If you're married, then your spouse can give another $19,000 to that person. Now, who are these people likely? They're going to be your kids or your grandkids, right? And so you can give up to $38,000 to a child or a grandchild, assuming that there's mom and dad, or mom and mom, dad and dad, and there's a couple. So you can do that. So that is giving a gift without having to report anything. So that's easy peasy, whether writing a check, transferring, doing a wire transfer, don't have to tell the IRS about it if it is less, if it's $19,000 or less per an individual, or 38,000 for a married couple. Now, if it goes over, well, now you're going to have to let the IRS know, and you're going to say, "Hey, I made a gift." Now, remember my $20,000 example? Then we would have to let the IRS know, "Hey, we gave $1,000 gift over." Now, of course, we're not going to want to go through that exercise of filing the paper and paying the extra cost to the accountant, enrolled agent, to file that gift tax return. So we are going to do little strategic things. It's more like if you give a larger gift, and where I see this happen is if we're gifting a child money to make a down payment on a home, or we're adding a child to title, which essentially is you're gifting them a portion of your property. That, of course, those are large gifts. Those are going to be gifts sizably higher than $19,000 or $38,000 collectively. So we are going to have to file a gift tax return to tell the IRS, "Hey, we want to take advantage of our lifetime gift exemption." So the IRS rules say every person has now $13.99 million. And if you were paying attention, you remember last year's $13.61 million, and it was lower the year before. What was it? 11? No, it was in the 12s and the 11s before that. All right. And it's changed over the years. So now it's 13.99 million. And that means it's like a gift card that the IRS has given you, and you can charge this to the gift card. So now your gift is going to be reduce the value of that gift card, just like you're using it, just like a regular gift card in a store. You've used it, so now you have a little bit less on the gift card. So 13.99, effectively 14, just for easy math. That's a lot, right? So we're not really concerned about making gifts so much. Most people aren't, because they have this ability to request the use of their lifetime gift exemption. So the great news is you can gift a little bit more than last year, because last year the number was 18,000 if you don't want to tell the IRS anything. And if you do need to report and use your lifetime exemption, aka your gift card, then it was a little bit more than last year too, because last year was 13.61. Now they said 13.99. So we have some options here to be strategic, because guess what? A little foreshadowing to what we're going to talk about at the end. That's going to change next year. That's right. There's no change in the law. So when I say change, just the numbers change. The law already says this. So the law is not going to change. If assuming there's no other new law that supersedes it that's passed. The law says January 1st, 2026, the value of your lifetime exemption reduced in half. So now our essentially $14 million per person is reduced to 7. So we're going to lose $7 million off our exemption. And so for a couple, that's $14 million of gifting power that's going to be lost. Now that might be meaningless for some people. Of course it is. And that wouldn't be uncommon, because you're saying, well, wait a minute, I don't have that much to give. So I'm not so concerned about that. In other words, if you have less than a $7 million estate and you're single, or less than $14 million in fair market value estate if you're married, then this matters nothing to you right now. But if you're over that, then pay attention, because this is important. We're going to need to do some strategic maneuvering, make large gifts this year before you lose the ability to make gifts. And who does this really apply to? So if you are single and you have more than $14 million estate, then we're going to need to take some action before the end of the year. So we're going to need to make some gifts and do some strategic thinking and planning before the end of the year. If you're a married couple and you have more than $28 million, we're going to need to do some strategic thinking, planning, and action before the end of the year. If the clock turns January 1st, the people I just talked about, you're gonna miss a huge opportunity. And that's going to cost millions of dollars because the new estate tax is going to be 45% of anything over those levels. So if you have more than $28 million and you're a married couple, and now the new level is only 14, and then in January and you pass away, well, that's a considerable amount of tax. 45%. You're talking the fact that you've just increased the tax burden for your family nearly $7 million. So, like I said, there's $1 million mistakes here that we want to get in front of. So we can use strategic things such as the annual exclusion amount. We can make large gifts. We can do some strategic trust planning, utilize life insurance, lots of things that we can do. That's just a few of the, like, probably about 40 different strategies that we have available to us. So just be mindful if that's you, if you're in that boat saying, oh my gosh, sky's going to fall down January 1st if I don't do something, please come talk to us because these solutions don't happen overnight. They're not going to happen in just a few weeks. They are more complicated strategies. It requires more thought, conversation, information, consideration. So we need to have the room to do this. So you don't want to come in December, November, you're really pushing it in October even. We want to have those conversations now. And so really, I'm really encouraging people to come to us before the end of July because we need that runway to be able to put these things in place. Okay. So another thing on tax laws, we have California. So just a couple key updates here, just so you know, nothing really earth-shattering as far as the federal tax that we just talked about. Little things that could be helpful, like you now can e-sign, like with DocuSign, for example, property tax documents, which you weren't able to before, but now you can. This might be convenient for you. It might be a non-start because you can really sign things in person. It's not an issue. But I can tell you in our practice, it's going to be helpful when we need somebody who is not local to sign a document. We could use DocuSign, and that's super helpful. There is some additional components as far as deductions for or non income that's calculated in your income, but it's not counted. Again, I'm not going to say deducted; it's just not counted as income in California. So if you received any money from the victim compensation board. There's a fund there that does not count as gross income under the state of California. So you're going to want to talk to your tax professional as far as how that's treated for the IRS, and certainly make sure that they're not counting it for California. And then if you have paid more property tax than you needed to, then there's going to be an easier way to get that refund. This is important, particularly when we have somebody who's passed away, a parent. Um, and that's the primary one. We have a parent who's passed away. They lived in their primary residence. They've passed away. Now that home is that primary residence is going to the children, and one child moves into that home. Now that's important because that is the only exception to the reassessment. And that remember, Prop 19 said any the parent child and grandparent grandchild exceptions to exclusions for reassessment are done. They're dead in the water. All right. Except if it was mom and dad's primary residence and they passed away and they were living in it and that was their primary residence at the time that they died and child, just at least one, they could have many children, but at least one of them moves in within 1 year. And then we will avoid the property tax reassessment in that situation. Maybe not entirely. There's a whole math to it, but it would be at most a reduction. A lot of times it would cancel out the reassessment altogether. So some children, adult children, want to take advantage of this, but you only have 1 year to move in, and in order to claim it, you have to file a homeowner's exemption form. Many of you who own homes are familiar with this, saying, I own this house, my primary residence, and you get a $70 discount on your property taxes basically every year. At least it's a $70 it ends up equating to $70 of dollars off of your property tax bill of how it's figured out if you claim this. But in order to claim the exemption for reassessment, you have to claim that your parents' house as your primary. So you have to file this form, this homeowner's exemption. And the problem is that there's usually a delay, right? So what's going to happen is your parent passes away, now both of your parents have passed away, and you have this house that they reassess. The county reassesses the tax and say, hey, now you owe a higher amount, but you're like, wait a minute, I'm moving in. They said, well, you haven't filled in the paperwork yet. You fill in the paperwork before the deadline, but in the meantime, you have to pay the higher tax rate. And so then they get your paperwork, they process it, and say, ah, well, there was an exemption, they overpaid, and so now we're gonna have to give a refund. And so we've seen that a lot over the last few years, and they've been really slow to process that paperwork and issue the refund. It's taken well over a year. They streamlined that. So good news is, if that's you in the future, you are going to probably pay a higher tax initially but you'll get a refund a lot quicker. All right. So next, earth-shattering news, and this is earth-shattering in my world, is that this law was passed to try to make it easier for people that had or lower value homes to pass those outside of probate without having a will or a trust necessarily. The reality is it was a savings clause, so they instituted this law because what was happening is that people that were lower income, that usually would have homes that were less in value, they weren't getting estate planning done either because of lack of knowledge, but there was perhaps a financial barrier there. So they said, hey, we're going to put a safety net, because what's happening is people are dying intestate, meaning without any planning, and they're clogging our court system with probates. And it would have been a lot easier if they just got some planning done, but we realized that they didn't recognize the importance, or they didn't have the money, or they didn't think they had the money to afford it. So they didn't get it done. So we don't want our courts clogged. So we're going to give them a little bit of a break in what's called a small estate affidavit probate, meaning that we can move and pass and transition property down to our heirs after a death without there having to be this whole court process. So you can avoid probate, the full probate, if certain things happen. Now, there was already laws like on the books about this, but then the numbers were pretty low. So currently, if we're not talking about real estate, a specific home, but we're just talking your assets in general. If you pass away and you do not have a trust, then your estate is going to go through probate with even if you have a will. So it doesn't matter. All right, in California, forget about the will. All right, the will isn't generally going to help most people. So even if you have a will, if your assets that are in your name are equivalent to more than $184,500, then your estate goes through probate. But if it's under that number, or I should say it's 184,500 and under, then it's just paperwork. So, like for example, bank account, that's $180,000, and that's the only account in a person's name when they pass away. Then their heirs are able to go to the bank, fill out some declarations and paperwork through a small estate affidavit, and the bank transitions the account to the legal heirs, the heirs to whom the California law says are heirs. So maybe it's a spouse, maybe it's children, maybe it's both a spouse and children. If they don't have any spouse or children, then we're looking at grandparents, parents, or siblings, or nieces and nephews, and down the family tree. If you have a will, then the bank has to follow the will in that situation. Again, we're not in court here, so this is helpful when we're talking about smaller amounts of money, and it's not per account; it's collectively in your estate. So the law here says if you have a primary residence, meaning it's a house you live in, and you pass away and you do not have a trust, then the house can pass through a similar small estate process. So where the value number is $750,000, and that's fair market value, not equity. So don't say, hey, I have a $1.2 million home. My equity is $400,000. I'm good because I'm mortgaged pretty high. No, it's the fair market value. That would not count for you. 1.2 million is the fair market value. That's higher than $750,000. This process does not work for you. What the process says is that, well, now your heirs can go to court and petition a court to transfer the home to the heirs. Notice what I said. The heirs go to court. What court? Probate court. Now, it's not a full probate, but it is a court action. So an attorney is likely going to have to be hired. There's going to be a delay to get a court date months down the road, and then you have to go to a court hearing for the court to actually make the order to transfer the property. So this is not seamless, all right? This isn't like, oh, it happens automatically. This is easy. There's a process for that. And if you're not finding this out and you're in error trying to sell the property, this is going to prevent you from selling it. You're gonna have to wait, do this process, which is gonna be a number of months and cost you some money to go ahead and do it. Where it would be a lot easier and faster if it was done, if a trust was in place. Plus, we're talking $750,000, right? For Southern California, that most properties nowadays are more than that fair market value. A majority, yes, there are some, and we have outliers in different neighborhoods, different sections, and if you have a condo, that makes a difference. But by and large, if you have a single family residence in Southern California, you're definitely looking at fair market value higher than 750,000 in most places. So this would not apply to you. So it's a hidden trap, people. You might hear this, oh, we don't need to have a trust, or I might just need to have a will to pass my house because of this new law. And it's a hidden trap because it sounds convenient, but it really isn't. So it's not $750,000 of equity unless it is, and there's still, and it's not no court, there's still court. So I would not recommend relying on this. If you have a home, whether it's a condo, single family residence, and as a and again, it has to be primary residence. So the other mistake I foresee is that people are going to just think it's a piece of property. Well, I don't live in it, but it's my condo. It's the condo I got for the kid, but it's not your primary residence, it's theirs. So that's not going to count. So make no mistake, it's a hidden trap. They try to make it easy, but I think by application, we're going to see a lot of problems down the road. So do yourself a favor and just put it in a trust. Okay. All right. So on that trust route, the next thing is simplifying small trust terminations. What does that mean? Well, at some point, a trust is going to run out of money. So you pass away, you've done your work, you set up the trust, you passed away, you transferred the assets transferred to the next generation or the generation beyond that, children or grandchildren in a continuing trust. At some point, the money is going to run out unless we're talking about one of the $28 million or more group of people we were talking about before with the federal tax and the exemptions. Those there might be multi-generational situations when we deal with things. You hear the words out or you see them out there called dynasty trust. Just think about dynasty, right? Remember that show, Dynasty, and then there was the Dallas, all that stuff from the early 80s. I'm old enough now that I remember that. So some of you that might be watching this don't, or some of my team would be looking at me with four heads. But those of you that I see on here, my guess is you probably remember those TV shows. So multi-generational, and we'll bring it to the fore, right? For a little, for the youngins. Succession, the show Succession, right? That is estate planning. That's all about estate planning, right? I could have wrote that show. And from what I see, maybe they, I know the show ended, whatever, but the Succession 2, we'll call it something else. But the point is that's a lot. That's old family. Well, not old wealth. That's that guy's wealth, right? Big wealth that can transcend down multiple generations because of the amount. Assuming it's not misused and people just are spendthrifts, but it's invested well that can last for generations. So or if you know the Whittier Trust, you ever heard that? The Whittier family, that's hundreds of years of wealth passed down. We're talking about going back to the end of the 19th century and moving forward. That family, the Whittier family's money still goes forward and takes care of the Whittier family all these generations later. And of course, they do other families as well. The Whittier Trust helps over 600 families of that level that we're talking about hundreds of years of wealth. So at some point, if you're not them, the money runs out. The money gets close. So do we still need to have a trust if they're only a little bit of money? It seems like it's too expensive to manage, to pay the trustee, to pay the accountant. We might be still paying an attorney to advise once in a while. That seems like a lot if there's not a lot of money in there. And we understand mom and dad set it up that way. So because they were worried about how the kids were going to turn out, but the kids are really fine. And we don't need to have this trust continue that's costing more money than it's worth. That number used to be $50,000 that you could just terminate it. The trustee could say, too bad, we're going to terminate it. But and the $50,000 would just pay out to the outright to the beneficiaries. They could take it and run with it. But now they said it's 100,000. So now a trustee essentially can terminate continuing trust earlier than before. They're just saying now we're giving them more options to end it earlier, saying that won't be cost effective. Really, below 100,000 left as principal in the trust, you can just pay it out, right? So you could do that without getting a court order. Now, if you had $100,001 in that trust, trustees beware. You cannot just say, we're going to terminate the trust. Everyone agrees, and just do it on your own, because you need a court order. You need court's authorization to do that. So if you have more than $100,000 in there, don't think you can just go ahead and do it yourself, even if no one's going to complain about it. Everyone's on the same page. All the beneficiaries are like, yeah, give us the money. We don't need to pay you every year. We'll do it. That's ours. We don't need someone else controlling it. You need to have court authorization. So, but if it's less, $100,000 or less, you can terminate it. Okay. Quick word on BOI. It's dead. Are we sad about it? Well, it depends on your perspective, but you know what? It's dead. It's sad. Rest in peace. End of story. Really, that's all there is to say. I'm not going to go back and talk about all the flippity floppity flippity floppities that was going on. That was probably, if you're getting our emails about it, where you're like, are these guys actually paying attention? Can they make up their mind? What is going on? That wasn't our fault. That was the law. That was courts. That was the U.S. Treasury. All in all, it is still the law to report, but FinCEN, which is a department of the U.S. Treasury, said they're not going to enforce it. So we have a law in the books that is not being enforced. Whether you want to still be compliant with the law, just in case they decide to enforce it, well, then you should go ahead and file the beneficial ownership information report. However, if you're of the position like, look, once they, if and when they start reporting it, enforcing it again, then I'll report. Then you just sit on your hands right now. But that's where it lies. So and we'll see if there's any more information or changes on that. I don't suspect so, but look, I've said lots of things internally about where I suspect things to go, and on this BOI stuff, it's like when I go try to play craps in Vegas, I always lose. So that's where it is. Take it or leave it. Better update. Trust. These are some cases. So interestingly, because I'm a legal nerd, hence the glasses today. I like I like to read cases. So it's not just, hey, there's a change in the law. This is the interpretation of the law. And why do I like cases? Because the law sometimes is not very easy to interpret. It's written poorly because it goes very quickly. We have non-lawyers writing bills, and we have concessions that are made. Just think about your copy paste jobs and how there's errors in them. That happens at the legislative level. So then we have a law that doesn't seem to make sense because there's technically errors in it, or things weren't thought through, and we as applied, they have the intent of where we're writing it, but these are people in a room basically writing in a vacuum. And now it's the law. It sounded good with words, and on paper it read well, but by application in the real world, it's messy. Doesn't make sense. We're missing issues. We didn't see things. So then we have the law to interpret it and say, you know what, this is what the law really meant to say, or it applies here, doesn't apply here. So we get into the context, which is kind of fun because there's these real life factual scenarios. And I like that because it's not so dry as this is the bright line rule. We're talking about how it affects real people. So um, these are some of the three that we've pulled out that are important for you to know. Reich versus Reich talks about changes that are made with your planning, or sometimes when changes aren't made with your planning and you get married. And here it was like a remarriage, right? So there was a remarriage, and some parts of the estate plan were neglected. What's often neglected in a remarriage? Beneficiary designations on accounts, whether it's a bank account, brokerage account. Most often, we're talking about a retirement account. 401k, IRA, Roth IRA. There were beneficiaries designated prior to the marriage that just kind of carry forward because those beneficiary designations aren't addressed. So we have things like, oh, my ex-husband or wife is still a primary beneficiary on my account, so we got divorced 10 years ago. And then my new spouse, I didn't put on there. Or I had my kids as the beneficiaries, and then I got married. And did I mean to put my new wife on there? Did I not mean to put my new wife on there as my primary? I don't know. We don't know because you up and died. So now we just have a document that says, well, the $1 million IRA goes to the three children. And the poor wife who was married and is now a widow doesn't get the $1 million or even a portion of it. Now, did the husband mean to change it? Again, we don't know. They're dead. We can't ask them. So the court dealt with that situation here, and the court said the IRA beneficiaries hold because hey, it's out of our jurisdiction essentially. We're the probate court, so this asset's not in probate because it had a beneficiary. So sorry, we can't do anything. You should have planned better. And so that poor widow is out the $1 million. Now, does she get other things? Yeah, but we weren't really talking about that in this particular factual pattern. They just dealt with the IRA. So, and if you have that situation and you wanted your spouse, you would have to be the primary beneficiary. You'd have to make a change. So, our mistake situations. Just think about it. If it was the ex-wife would have got the $1 million, and there's nothing the new wife could have done about it, or the children could have done about it. And we've seen those situations. So we want to deal with that. And as a related thing, with a 401k, so not an IRA, but a 401k. 401k is a construct of a different group of laws, right? So these things, 401ks, IRAs, they exist because laws create them. Right? We didn't just sit there and say we want to do something called an individual retirement account. And we had to pass a law in the tax code that creates that. Same with the 401k, but that laws are under ERISA or ERISA. So ERISA laws actually there's a different problem that can arise because ERISA laws give credence to the omitted spouse. So our example from Reich versus Reich, if this was a 401k, husband dies with a $1 million 401k, and the beneficiaries were his children that he had with his previous wife, that he then brought those kids into his new marriage. Right now they're adults. We see this. This is our blended family, second or subsequent marriage. Husband brings in adult children. Adult children are the beneficiaries of the 401k. And then he dies, and new wife is not named as a beneficiary in the 401k. All right, well, you say, hey, Reich versus Reich says, too bad, new spouse. You should have got your husband to do something about that. Well, that's with the IRA. With the 401k, ERISA laws say, hey, that stinks. We're not going to accept that. We're going to give the new wife a right to the 401k principal. And so it doesn't matter what's on the beneficiary forms. If they never filled anything out, we still have the old spouse on there. We have on purpose the adult children. Then it doesn't matter. There is a presumptive right that the new spouse or the spouse at the time of death is the primary beneficiary. So that ERISA law supersedes what's on the forms, unless the spouse gives consent as consent waiver. It's called a spousal waiver. I understand that I have a right to this, but I'm giving that right up because I know that who these beneficiaries are, and I'd rather these beneficiaries get the money than me. And sometimes that works out and everyone's on the same page because, if you're getting married a second time, you're both bringing assets into the marriage and then you're comfortable with that because it's fair because they're signing the same thing for yours. And so a lot of times that's, there's equity in that. But if you're not paying attention, then when you pass away and you haven't updated your beneficiary designations and you have a 401k and or you have an IRA or Roth IRA, you got two different divergent results here. And so that's important to know. The other is this Trotter case. It's don't amend your trust by email. Well, you might all be saying like, yeah, no kidding, or it's a kid, no kidding, Sherlock. I will not use foul language. I was told this was a clean family show, but it would seem pretty obvious, right? Don't amend your trust by email. So I'm going to send an email out to my kids. I know I have a trust, but I'm going to change the terms of the trust, and I want this instead. Email, send, boom, and then now I can die. Well, that's what happens in this Trotter case, and the court said, no, you can't do that. You can't. Email alone's insufficient to amend the trust. There's a lot of other ways you can amend the trust. There's the law says, hey, there's this way you can amend the trust. Your trust document could see a bunch of additional ways to amend the trust with an official amendment in writing, because that's what the law says, and it's in writing amendment by the settlor, the grantor, the person who made the trust. Right? That's the statutory way. Now, on top of that, your trust can say, well, it could be orally, it could be verbally, not just in writing alone. Conceivably, I guess you could put email in there because that's part of writing. Because I can email a change, but that has to be in the terms. Like, there's no trust out there that I've ever seen. Now, I haven't seen every trust in the whole world, but I'd be willing to put good money. And I already told you I'm bad at craps in Vegas, but yeah, I'd be willing to put good money. The odds are very good here that if there is a trust, there's only one of them that ever says that you can amend by email, because that would be just catastrophic, arguably malpractice to put a term in there like that. You can amend your trust by emailing out to your beneficiaries a change. No, that just doesn't happen. So, and similarly, you can't just write on it either. I mean, you can, but you're causing major problems. Like, oh, I want to make an amendment. I know I can't email, so I'm just gonna handwrite on my original document or the copy of it, and this is my change and put in the margins. We see that from time to time. Can't do that. It's going to cause a lot of problems. It's most likely not going to work. There's going to just create arguments whether that a holographic will that you're writing out on top of the trust is a proper amendment. And that is, guess what? You're going to have a new case named after you. I don't know about you. At some point in my life, when I was in college, I aspired to have my name on the building. Like, that'd be great. Be named after something. I don't want my name in a case that some person studying, years from now in the legal books going, today we're going to talk about the Snyder case, that idiot who emailed the trust amendment. No, I don't want to do that, and neither do you. IRA proceeds. We talked about that already. That's what right versus right. All right, shifting topics now to, well, I guess not. It's a good segue. That wasn't done on purpose. Retirement stuff. We were just talking about 401ks and IRAs. Let's talk about you not dying, right? Thank God we're alive in Kevin's examples for once. You are alive with this, all right? What can you do with your retirement? Well, we have a law that was passed back in 2020, back during COVID times, which seems eerily so far away, but not that far away at the same time. The Secure Act, but it says Secure Act 2.0. There was a reboot of this. They've added over the years since Secure Act was passed. They've passed little updates, and there's been updates with regulations. So now we're effectively what's called Secure Act 2.0. So for you people, I say you people that are alive, yes, because we only have living people on the show. But maybe we have others. We have people from that are ghosts watching this here, and they're looking at it. Oh, shoot, I could have done that. But we're going to talk about other stuff after you pass away in a moment. You can add a special catch-up contribution. And here are the amounts that you can do. So you can get a little bump here. There's like, hey, you can catch up a little bit more. We've raised the levels. If we're talking about now you've died, so now people that have passed that are watching this, you can pay attention even closer. But seriously, a lot of you have heard about the 10-year rule. Now that was what the big thing out of the original Secure Act was. Now you pass away, you leave this IRA to your beneficiary, not your spouse. There's no 10-year rule for a spouse. Nothing. The spouse gets to hold principal from an IRA for the rest of their lifespan, their life expectancy, which usually is within their lifetime. We're talking about an inherited IRA, because that's what happens with a 401k or an IRA. It becomes an inherited IRA. That's what the beneficiaries receive, an inherited IRA account. for by and large, you're going to have only 10 years to keep that money inside that inherited IRA. That's important because this inherited IRA is, remember, it's growing. These are investments, so it's growing tax free. And then the benefit was, well, then you're going to, when for the person who opened it was when you hit the required beginning date, which is 73, then you can take out the minimum distributions and they come out taxed, not at capital gains tax rates, but your personal income tax rate. So it was a way to grow wealth without the higher taxation. So that was the idea. That's why it was a retirement account. And of course, we prevent you from accessing it before a certain age, 59 and a half. But then at the same time, we want to tax you on it, so we require you to pull money out at a certain age. That's the structure. And then when you gave it to like your kids or grandkids, then they were allowed to keep that inherited IRA open for many, many, many years because the length of time was measured against their life expectancy, which would be decades. And same, they were required. They didn't have to wait to 73. The law said, well, they're required immediately to start taking it out in minimum distributions, but the amounts are small because the length of time they can keep it is long. So again, historically, transferring from generation to generation, this was a way that you can turn $1 million into $3 million because your child or grandchild was only taking out small increments at a time, whereas the principal was growing because it was invested. And generally, your kids or your grandkids were going to have a lower income tax bracket than you were, at least for some of the time. That's all done now. Now it's just 10 years, unless your beneficiary is a minor, and a minor being they're under 21 according to the Secure Act. Then you can stretch it, then they can have it open until age 31. Unless your beneficiary is chronically disabled, then this rule doesn't apply to them. If they're a spouse, this rule doesn't apply to them. You leave to a sibling that is no more than 10 years younger than you, this rule doesn't apply to them. So really, though, for a bulk of people, this rule will apply because they're leaving if it's not to their spouse, it goes to their kids. Their kids are adults at this point, older than 21, and then the 10-year rule is going to apply. And generally speaking, most of those kids are not chronically ill. It's going to go to, or disabled, is going to go to this beneficiary, and they only have 10 years to keep it in that account, which means what? It means they're going to get taxed a lot more on it. So something to know. So people were saying, oh, great, I'll just defer that tax. I'll hold it in there, it'll grow, and we'll take it out in 10 years. Because I don't know what the market's going to be every year, whatever. I don't need the money now. We're just going to grow it and then we'll pull it out. Maybe the law will change in the meantime. So I'm going to hedge my bets and just keep it in here for the next 10 years. And the law says, no, you can't do it. They got wise. And they said, you're going to be required to take out a minimum distribution. So your parent dies, you get the inherited IRA, you now have to start taking out minimum distributions every year. And then by the end of the 10th year, everything has to come out. So they want their little pound of flesh. So you're going to need to get in contact with your accountant to know how much are you supposed to take out every year, because that is based on your life expectancy. So it's not, we're not going to amortize it. The law doesn't say you have to take out a tenth every year. It says you have to take out a minimum distribution. So you're going to need to know what that is because the penalty is huge, right? There's a penalty. If you don't take out the right amount, boom, they're going to hit you with a penalty. And that's going to be a lot of money. And we don't want to do that. Sorry, I get choked up about taxes like that. It's very sad. Okay. So, what is sad is the fact that there are people out there in the universe that take advantage of our seniors or elderly because they're vulnerable. We know this. There's all sorts of scams out there. We read the paper invariably, at least once a month, there's some feature of some scumbag that took advantage of a poor old woman, poor old man, ran off with their money, did something just really, really bad. And we are very angry. And I get very angry when I see that it's another lawyer that did this, just like in this Heron case, Heron versus George. And this dealt with a lawyer that took advantage of a person. It was a father who had dementia, but when I say dementia, doesn't mean he didn't know where he was. He had a diagnosis of dementia, but this other child hired this lawyer, the scumbag lawyer, who came in and got this father who was at assisted living to sign an engagement agreement, a retainer agreement, pay an obscene amount of money, $100,000, to do some sort of work. I don't even know that they got the work done. It doesn't even matter. I can't even conceive what 100 grand would have been to do. Obviously, the lawyer's a scumbag, was trying to steal money and was probably in cahoots with the other child that they were going to split the money. So all this went to the courts. Of course, the other children got a wind of this. The dad was upset because he felt hemmed in. He couldn't do anything and had regrets, and then complained about it. The lawyer wouldn't give the money back. Said, "Ah, you signed the contract." Like I said, this guy's a scumbag. And though I think it was a woman in this case, but doesn't matter. The attorney's a scumbag. The court, and so they battled over it. They said, "You know what? This was wrong. This was undue influence." And the attorney said, "No, it wasn't undue influence. They did not prove that this man was incapacitated. He knew what he was doing." And so, in order to prove undue influence, you have to show the man was incapacitated. And the court said, California Appellate Court said, no, that's not true. Under the Elder Abuse Act, which deals with restraining orders for elder abuse, so they pursued a restraining order against this attorney and said, "You got to give the money back and do not have any contact with my father ever again." And the court sided with the family and said, "You know what? They did not have to prove incapacity. They just the law doesn't say that. It says undue influence. That doesn't mean the person's incapacitated. They were unduly influenced. There's a lot of factors. The fact that he had a dementia diagnosis, sure, that played into that. His age played into that. The circumstances surrounding that. If we said otherwise, then nobody would. It would be a disincentive to pursue. It would be a chilling effect on pursuing these elder law restraining orders. So we're not going to have incapacity be a requirement. So that big thing is you can still pursue an an elder law abuse restraining order, even if you can't prove that the person's incapacitated, or arguably they're not incapacitated. You just have to show undue influence. So this is a huge win against the scumbags out there. So again, for senior rights, an important thing is our CCR, so continuing care retirement communities. I said that really fast. Continuing care retirement communities, CCRs, CCRCs. These are the communities that say, hey, we have independent living, and when you can no longer live independently, we have assisted living, and we can no longer live assisted living because you have dementia, you can go into memory care, and or if you need skilled nursing, you don't have to go to a skilled nursing facility, another nursing home. We have that level of care here. So literally, you come in, you pay a bunch of money to have this ability, you have a big buy-in, and say you can live here in this community for the rest of your life. And no matter what your needs are, we got you covered. So those are the CCRCs. And what the law now says is, this is a Senate bill, 1352 says, okay, that's all well and good, but the continuing care retirement community has to provide the residents' rights that they have, because remember they're independent, they can assert themselves, but if they're less independent, they might not feel that they can assert themselves. We're talking about undue influence, and the gentleman feeling hemmed in because he didn't know what he could do, not do, and so this is the same idea as saying, hey, look, we want to make sure that residents know their rights that they have. That what if they don't want to be there? I know we paid a lot of money to be here, but I don't want to be here. Do they have to stay? Do they have a right to leave? What if something's not going right? They arguably are getting abused, or they're not being treated well. What sort of complaints and rights that they have, or are they going to feel like they're institutionalized? So and sometimes this was happening. And so what the law is doing, the public policy is like, look, we want to put it out there, be transparent. We want to level set. Everybody that comes in here, the residents, know what their rights are at the beginning, and then as their cognition or physically abilities, their aging process sets in, they might forget what they knew before when they were told at the beginning. So each stage, we're going to give them their resident rights. And so if you're listening and you're like, look, well, wait a minute, if they go to memory care or the skilled nursing, they might not be aware. So if they just got a piece of paper saying their rights, is that just like, they're technically checking off the box here, but really effectively it's meaningless because the resident's not going to understand that. So if you have a power of attorney for a parent, you're a conservator for somebody, or you're a trustee for somebody who is in one of these communities, and they're getting transitioned, and you have authority to act on behalf of these people. So you got to get a copy of that. You can demand that because you're acting on behalf of this person, right? So that's important. All right, our veterans out there, thank you for your service. Here are some of the updates that are important to you, or if you are a spouse of a veteran who is not yet passed away, certainly if they have passed away, you're a child of a veteran that has not yet passed away. This is all for you. So the Dole Act, very new, and it's named after Elizabeth Dole, Bob Dole's wife, who was a both Bob and Elizabeth were very big veteran advocates, naturally, because Bob was a veteran himself, and so they named this obviously she passed away too, so they named this act after her. And what it does and what it says, it is providing more resources and the ability for the VA to expand its network. In other words, if you want to get healthcare paid for by the VA, you don't necessarily have to go to the VA and use VA doctors. So you can, of course, always, if you're a veteran, go to your own doctor and still be in the VA healthcare system, but now your own insurance has to pay for that doctor. Whereas here it's saying, you know what, we're going to cover other doctors who are outside our veteran network, so they're not part of the VA, non-VA doctors. We will cover some of those costs for some of that care outside the VA network. So expanding the care out, providing more which is beneficial for the veterans, right? So they have more options and sometimes faster treatment, because some of the knock on the VA is like, I just get stuck in that maze, and then we don't get treatment. It's just I got to go see one person after another, and it just seems like I'm chasing my tail. I'm not getting that appointment, and they're slow to make the appointment. So that's supposed to help with that. And the other thing is that for in-home care or assisted living, this act is supposed to provide for some more options there. So if you're a veteran, you might be able to get not just money in the bank, which we'll talk about in a second, to pay for care, but they will pay directly for that care for in-home care, kind of like IHSS does, in-home support services does for the Medi-Cal, that the VA is going to have something like a corollary, maybe not structured the same way, but the concept is the same. Or there's going to be placements that they'll pay some of the cost for. So still new law. So the applications we will see as it comes out. People try to take advantage. The VA is rolling out things, but that is very, very important. You should know about that. Aid and attendance, been there a long time. If you have the veteran needs assistance with 2 activities of daily living and meets other service and financial requirements, can get a monthly allowance up to about $2,400 to offset cost of care. And it comes to them and their bank account to be used by them or legal representatives. So it's a lot more flexible. If you're a surviving spouse, you have basically it's aid and attendance for surviving spouses. It's called something different. It's called survivor's pension, but it is less money, but still impactful. So you're still getting almost $2,000 a month for the care of the non-veteran surviving spouse. Now, pay attention. Now, this is for people, the veteran's still alive, but needs care. And guess what? They're at home, and who's taking care of them if they're home? If they're married, surviving spouse or a spouse, right? Sometimes an adult child. Guess what? That spouse, that child, they go ahead and they can apply now under VA caregiving assistance and get money for them. All right, get money for them. And so this is an upgrade. Used to be that they can get money by saying having a VA caregiver agreement, but then that just meant the veteran could pay their wife or their children from the pot of money that they're getting from the VA themselves. So it's just really more of a transference of funds that wasn't going to be penalized. Here, it's saying, no, now we have an additional bucket. We have the aid and tennis bucket for the veteran or the surviving spouse, but now we have a VA caregiving bucket for the family member that's caring for the veteran, which is usually a spouse or an adult child. We're going to give money to them directly. And there's 2 tiers. Again, the max tier is about $2,400. The veteran either needs assistance with 1 activity of daily living, tier 1, or 2 activities of daily living, tier 2. VA, an activity of daily living is transportation. So if you have a veteran that no longer drives because they can't drive due to a disability, which might be dementia related, guess what? That's 1 activity of daily living. All right. So you can get tier 1 probably pretty easily. Tier 2, a little bit more difficult. Because now the veteran needs assistance with other activities of daily living, showering, dressing, transference, or getting out of bed or the couch, making meals, that sort of thing. So maybe you get they're there and you can get that too. This is an important rule, Packard versus Packard, about no context clauses. So a lot of times in California, well, I hear, oh, well, we want to put a no context clause in there so nobody can fight about it. Anyone who fights about my trust after I die, they're out. And we see this in there, and people think that that's actually going to work. And the reality is that it might work, it might not. There's a split opinion on the California Court of Appeals whether a no contest clause can be applied or not applied. It doesn't work. All right, so it's a crapshoot. And again, I told you I'm bad at craps. So, and you should be too. It's really not a game that's geared for us to win over a long period of time. But that aside, no context clause here was saying that the beneficiaries were just seeking court clarification about a term of the trust. And they're saying, hey, we think that this is wrong and we're looking to amend it to be more consistent with my parents' intent. We don't think that the lawyer who drafted it up did a good job, and it doesn't match what we know our parents' intent was. And that's all we want is the court to change it to be consistent with our parents' intent. And of course, the other beneficiaries are saying, no, can't do that. And you're contesting, and so therefore you get nothing, and we get it all. And the court said, no, seeking clarification or seeking a request for a change to be consistent is not a contest. And so the no contest clause doesn't apply. And the 120-day limitation doesn't apply because you have 120 days to object to contest a trust after you receive notice of a death. So that statute of limitation is very short and doesn't apply here because that was the other thing. They raised their hand like a year later and they said, hey, Judge, I've had a problem with this. I don't think that this is what my parents really intended. I'm asking you to change it. And the other side was saying, no, you had your time to object and you didn't object. Too bad. You're late. Bye-bye. Get out of here. And by the way, it's no contest, so you lose. And the court said, no, this is not a contested thing. They're asking for a change and a clarification. So they can ask that even a year later, and they're not prohibited from being a beneficiary because it's not a contest, so the no contest clause doesn't apply. Okay. Going through a couple of these are really fast and easy. I took care of all the heavy ones first. So we have an expanded definition of what digital assets might be and who is allowed to access them. So fiduciaries or conservators or trustees now by law can access these. In addition to, you probably want that in your trust and your power of attorney anyway, just to be certain and be doubly sure. Okay, conservatorship protections. Much like our CCRCs, the communities, there needs to be notice of when things happen. Here they're saying when a conservatee, so the person who is that lacks capacity, who has a conservator, is being moved. There has to be a notice that goes out to people who are entitled to receive that notice. So just think about it like this: there's like the children out there. Mom has a conservator now because she didn't have any planning, and now the court had to appoint conservator. The conservator is like maybe it's a brother, maybe her brother, like the uncle of the kids, or maybe it's one of her children, and that person starts moving mom around. And now the other kids or part of the family has no idea where they are because they've sequestered them. Or they've died and they don't tell the rest of the family. So this law is saying, no, 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 you can't do that. You have to give notice when there's a movement of the person or there's a death of the person. For business owners, some things we got to know about. You'll get these slides out here, but if you're a landlord, there is things you got to know to be compliant with the landlord-tenant law, so you are not sued. And if you are sued, they can go get your assets unless you have a corporation or an LLC in place. And if you don't, let's talk because that is super important. And if you say, hey, I got it in California, we got to talk because the California LLCs aren't going to protect everything you want it to. And we'll talk more about that offline. So if you don't have an LLC, or a corporation. If you do, if it's California based, then we need to talk. And those of you who are teachers know all about this, the windfall. So you now can collect Social Security even if you've been working as a teacher and we're getting your other retirement from the districts. You also can get Social Security. This is a good thing. This is a windfall. But the challenge is they're saying, oh, wait a minute. Now all these people are going to get paid that we weren't counting on, that didn't contribute. And so now all this is going to go out the door and we're going to bleed down Social Security. So that's going to be less. And pretty soon there's not going to be any Social Security, plus certain elements of the government want to change that anyway. So we're going to have a recession, but it's going to be triggered by this windfall law that say that teachers get Social Security basically, or government workers get the Social Security that they weren't entitled to before. So we need to be careful and just be mindful that could happen. There might not be money for Social Security. So how else are we going to make sure that we have a cushion for our retirement? We'll take a look at this later. These are all just some extra things for you to take a look at in the slides that aren't really related to trust, but I think that might be helpful for some parents to know. You can click notarization online. And on the horizon, what's next as we try to land this plane relatively on time is what's coming next. I already talked about it. It's the sunset. And that's why we have this nice picture. So the sunset of the exemptions, meaning the law that went into place that was passed in 2017, the Tax Cuts and Jobs Act, that was signed into law by President Trump back in 2017, went into effect 2018. And it said this law is going to be good for the next 7 years. At the end of the 7 years, the beginning of the 8th year, then the rules here are going to sunset and go away. And we're going to go back to the way the rules were in 2017. So what the break was is that it lowered the income tax brackets, it raised the lifetime exemption rates, and it froze the capital gains tax at the 15% to 20%. So that was a tax break. And they said that was going to be good. So now that tax break is sunsetting and going away. January 1st, 2026, it'll be gone away. We'll have higher taxes. The tax brackets will go up 3 to 4%. And then we're going to have a lower estate tax bracket, state tax exemption. So we already talked about that. What that means, higher taxes for those that have more than $7 million, or for married couples that have more than $14 million. And we're going to raise the estate tax from 40% to 45%, and capital gains are going to be affected as well. So that's kind of throwing everyone in a tizzy, because now we got to rush and do some tax reform and get that new tax reform, meaning new tax laws, to supersede this law that's already in place. So if nothing's done, there is a sunset. The numbers are going to change. The law has not changing. The numbers are changing. But if they do tax reform, they pass new laws, then of course the numbers, we're going to see what the law says. So what are they trying to do? They're trying to keep the income brackets where they are now. They don't want them to go up because nobody likes income taxes going up. They want to make sure that either get rid of the estate tax altogether, or at least keep it at the high levels that it's at, not let it go down. They're looking at that. And if you have if you know in your filing your taxes, you know, hey, look, I'm paying mortgage interest and property tax, I can deduct some of that. And back in not even the day, like it wasn't even that long ago, that you could deduct a lot of money. You had a mortgage, and you know you can deduct 20,000 easy or more. And certainly people that have bigger, more, commercial properties, all that, they have these big balances of mortgage on it, and they pay a lot of interest, and they want to use that as a tax deduction. That was great. That was great for everybody. And so what they capped that at $10,000 many years ago under President Obama. They capped that 10,000. It's called the SALT deduction. They capped that. So they want to either raise the cap higher, maybe to 20,000, or get rid of the cap. All right. So that's an important tax benefit there. So they're going to be looking at that. So what does that really mean for everybody? Okay, so I get asked all the time was, hey, look, the Republicans have control of the Congress. We have a Republican president. So this is going to be pretty easy street, right? We're going to get everything we want. We're going to get Income tax isn't going to be raised. They're going to either do away with the SALT cap or raise it. That'll be helpful for us. And they're going to get rid of the estate tax, right? We just don't know. Why? Because they have to get stuff done. There is only a slight majority in Congress of the Republicans, and not everybody is as aligned with the current administration on the Republican side that as they were back in the first iteration of the Trump presidency. Now they have about 5 or 6 senators that they're going to need that they might not get. Unless they make some concessions. And so those concessions might be, they're doing this horse trading to get the bill passed. The estate tax exemptions might fall by the wayside because that's the least impactful of all of these for a majority of people. Majority of constituents are worried about income tax and then the SALT deduction, capital gains and keeping it the same. So they might have to do some horse trading, and that was what's going to be a victim of that horse trading is the estate tax issue. So there's a good chance still that the estate tax is going to lower, just like the law says, because that piece of the law is not going to change. Also, just getting stuff done takes a while. So they might not get it done. Maybe eventually they do, but they don't get it done before December 31st. And now we're into 2026. And they don't get it done until maybe later in 2026 or in a subsequent year. And what happens if you die then? Well, you're going to have millions of dollars of hundreds of thousands of millions of dollars of a tax problem that could have been avoided. So when we saw that in 2009, the reverse situation, Democrats were in charge. Estate tax was going to go away by the end of 2009. All they had to do was do tax reform. They had everything lined up. They were in power, and they didn't get it done until December of 2010. So people who died in 2010, there was no estate tax, which was great for those people that they would have normally been taxed. So there was like a little softball, slam dunk for the Democrats. They didn't get it done. Some people might say this is a slam dunk for the Republicans, but they still got to get it done. So we'll see. The whole thing is we'll see. But there are still opportunities in which this is not going to happen. So if it's going to affect you, like I said at the beginning, we got to get stuff done because you have to believe and plan just as if the law is not going to change. Because that's the best plan. That's going to be the worst outcome for you. So plan for the worst, hope for the best. Thank you for coming. Of course, as always, here's how you get in touch with us. Pretty easy to find. You can email us or give us a call. We even have a way on our website that you can submit your question request for a meeting. Those are the easy ways. And we'll just preview our next upcoming event, estate tax sunset. So everything that I talked about today, warning you what to do, we're next time going to talk about the actual things you can do. So this is more into the meat, and you might be a little bit more interested in this, if this might affect you, or somebody that this might affect. Tell them about this, please, because like I said, this is significant. If you can help a friend save hundreds of thousands of dollars and millions of dollars for their family, wow, you're a good friend or you're a good advisor. Right? If you're here and you've got clients, this might be affect. So invite them. So that's coming up. That's Friday, April 11th, 12:30 here on Zoom. All right. Thank you, everybody. Go have a great weekend and keep being amazing.